When Americans think about politics, they often focus on Washington, D.C. We follow presidential elections, Supreme Court decisions, and congressional debates. Yet many of the most important political decisions affecting our daily lives are made at the state level. States determine election rules, education policy, criminal justice policy, tax structures, and much, much more. They also serve as testing grounds for new policies and at times become major opponents of federal initiatives. To help us better understand the roles of states in the American political system, I am pleased to welcome Professor John Dinan of Wake Forest University. Professor Dinan is one of the nation's leading scholars of state politics, state constitutions, federalism, and direct democracy. His research examines how states exercise power, how state constitutions evolve over time, and how states interact with the federal government in our federal system. Today, we'll discuss direct democracy, state constitutional politics, and the increasingly important role states play in supporting or resisting federal policy initiatives. Hello, I am Marvin King, and this is Civic Lens. John, welcome to the show.
Thank you so much for having me on.
Really appreciate it. To get started, as media has homogenized, Americans spend far more time paying attention to national politics than state politics. Just real briefly, why is it important for citizens to not ignore what is happening in their state legislatures?
So it's always been important for people to pay attention to their state governments, but I would say that two developments in recent years have made it even more important, or have at least alerted people to its importance. One of those developments was COVID. 6 years ago, a lot of people were reminded that some of the most important decisions made in responding to COVID were not being made by national level officials. They are being made by their governors, their state legislators, their mayors, their city councils. That was a big reminder to people about the importance of state and local governments. And a second development, 4 years ago, the U.S. Supreme Court handed down its decision in the Dobbs case and basically said states had always had some level of responsibility for making abortion policy. But the U.S. Supreme Court 4 years ago basically said, we're giving full responsibility for all intents and purposes back to state governments for making abortion policy. That was a reminder to a lot of people that the decisions they make about who they're electing to state legislatures, to governors, or state courts were the key decisions that were going to be made about the future of abortion rights and abortion policy.
Those are great examples. We saw with both COVID and with the Dobbs decision, a lot of civic activism on both sides of those issues. Of course, some of our students today are, when I'm trying to think when COVID happened 6 years ago, some of them were in their early teens still. And so for some of them, I imagine it was probably their first time thinking about local government and states. So one thing that surprises my students is that states often operate under very different constitutional structures. Could you give one strong example of how state constitutions or the process of writing constitutions differs from the U.S. Constitution?
First thing to be said is about half of Americans, polls show, don't realize their state has a constitution. Everybody knows about the U.S. Constitution, but when we ask people, are you aware that there's a Virginia Constitution or a Montana Constitution? We're really talking about only about half the people knowing about that. Once people do turn to look at their state constitutions, they're going to notice a lot of different things. First of all, there's a lot of rights that are guaranteed through state constitutions and state Bill of Rights. For example, 10 states have in recent years passed abortion rights amendments that guarantee some level of abortion rights. 2/3 of the states have victims' rights provisions, protecting crime victims. We turn to a number of policy provisions. The vast majority of states have balanced budget provisions in their state constitutions in a way that's not found at the federal level. And then finally, just one brief example, the structure of government differs dramatically. We talk about having a unitary executive at the federal level, that the only people that you vote for are the president and the vice president. But in a number of state constitutions, they provide you might actually elect separately as many as 10 different executive officials. You might be voting for governor, for lieutenant governor, for secretary of state, for attorney general, for auditor. Makes for a very different constitutional structure.
It really does. I know here in Mississippi, we have a long ballot when it comes to the executive offices, agriculture secretary, transportation, treasurer, auditor, public service commissioners. And, and I feel like I'm pretty knowledgeable about these things, and I still have to look up, like, what is this person doing again? And so it's a challenge. It definitely brings it home that the democracy we experience really does make a difference as to which state you live in, and how you interact with all of these different elected officials and what their responsibilities are. Well, one example to me of where citizens have different experiences with their democracy is when I teach them about the initiative and referendum process. In Mississippi, we don't really have a functioning initiative process. There was, but then the state Supreme Court ruled that the process was not effectuated in a constitutional manner. So for many students, these concepts can feel somewhat abstract. So first, could you talk about when we say direct democracy, what are we talking about here?
So, about half of the states have some form of direct democracy in that fashion. What we mean by direct democracy is that it removes the legislators from the gatekeeping role and allows the people to initiate policies or, in some cases, constitutional amendments in a way that bypasses the legislature and where the people can say, we want to vote on adding this law to the books, or we want to vote on adding this constitutional amendment to our Constitution. And the legislature basically can't prevent that from happening. So the legislature loses its gatekeeping role. That's what we call the voter initiated process. There's also the voter referendum process, where sometimes the legislature will pass a law, and in many states, that's the end of the line. But in states with a referendum process, enough people can force a vote on that already passed state legislation and say, we will actually want to vote to make sure that we actually, a majority of us, are in favor of this law. And if we aren't in favor of it, that law will be removed from the books. There's still a further procedure, which is in about 19 states, and that is the recall, the ability of, suppose you have a governor who's elected for 4 years or some other official elected for a set term. In states with the recall, you can be midway through the term and enough people can say, we actually want to force a vote on whether to end this person's term prematurely. And if enough people vote yes, that person could be recalled from office. So the initiative, the referendum, and the recall are all forms of direct democracy.
I think a good example that can tie in your first response to COVID and recall was, I want to say maybe it's been 2 years now in California. There was an effort to recall Gavin Newsom. And I believe much of that was driven by his response to COVID. Is that correct? If you remember that?
That's a very fair assessment of that. So, yeah, California, we often think of it as one of the kind of the hotbeds of direct democracy. And so we go back 20 years, and there actually was a successful recall of a California governor, Gray Davis, and that's what actually led to Arnold Schwarzenegger taking office as governor through the recall provision.
That's right. I remember one other case. It was in Florida. Voters had passed an initiative to restore felon voting rights, but then the legislature rebuffed the voters.
Sure, and I think this gets to something that we were planning on talking about. Legislators are not very much fans of direct democracy in many cases because it removes their sole power. And so the example you gave, a number of people in Florida said, let's get an initiative together and pass an amendment to the state constitution that will make it facilitate the enfranchisement of voters who previously were disenfranchised for felony convictions. But in this case, as in other cases, sometimes to actually implement that requires the legislature and other governing officials to actually take steps to put that into effect. In the minds of many of the voters who supported that initiative measure, the elected officials did not take all of the steps that they could have to actually effectuate it and actually blunted the effects of that initiative in key respects.
Well, so why do you think it is that some states adopt the initiative and referendum and recall process while others do not? Is it simply that they can't control the output of these initiatives? Is there something else going on?
Yeah. So states with the initiative and referendum basically adopted it in two waves. The vast majority of states with initiative and referendum adopted it in a 20-year period from about 1900 to 1920. In fact, the vast majority, about 80% of states with direct democracy, adopted it this key progressive era period where there was a surge of interest in direct popular participation. And basically, any states that were revising their constitutions during that time gave serious thought and consideration to adding the initiative and referendum. Then there was another wave that's really the 1960s and 1970s, where there was again another surge of interest in popular participation. Another handful of states adopted direct democracy at this time. Mississippi didn't adopt it again until 1992. We should say that's the second time that Mississippi had tried to adopt the initiative and referendum. They were part of that initial wave in the progressive era. But interesting enough, the state Supreme Court struck down the initiative process in Mississippi. The people of Mississippi were granted the initiative and referendum process again in 1992, only, as you mentioned earlier, for the state Supreme Court to strike it down again about 5 years ago. So, but my point here is there's basically two key waves in American politics, and that swept some states into the ranks of initiative and referendum states. It's a bit of an unusual adoption, though, because in most cases, the legislature would have to agree to put the provision adopting the initiative referendum on the ballot, and legislators are natural enemies of the initiative or referendum process. And so there has to be a significant surge of support to overcome that opposition from legislators.
We don't see elected officials very often willingly part ways with power.
They don't, notably, if we talk about one of the distinctive features of states is that term limits for legislators are not an option at the federal level. Supreme Court said that's not something that states can do on their own, but it is in effect in 16 states where actually legislators are term limited. In the vast majority of those states, the legislators were not fans of limiting their terms. It came about through direct democracy. In only one or almost two states have legislatures actually gone along and said, okay, we'll agree to limit our terms. So, yes, legislators, like other institutions, are not generally looking to give up their power.
I was in Michigan once doing some work and I met several state legislators. And, to a person, they all had plenty of reasons why the term limits were awful. Mostly they said, well, you're just getting rid of expertise, the institutional memory. And I thought that was a fair point, but I also thought that was maybe a self-serving point as well, because nobody else can get expertise if you're always in office. So let's shift to state federal relations. During both the Trump and Biden administrations, we've seen this before, of course, but anecdotally, at least to me, it seems like it's really ramped up where we've seen states challenge federal policies in court with a lot of frequency. So has state resistance to federal directives become more common, or is this maybe media magnifying conflict?
No, I think it's very fair to say that it has ramped up in the last 10 to 15 years, especially. Now, we should say that there have been times in American political history where there were times in which states embraced the doctrine of nullification and said, actually, South Carolina most famously said, we embrace the doctrine of the ability of a single state to nullify the effect of a federal law back in the 1820s, 1830s. That's seen as a discredited notion now. There was even the doctrine of interposition, which can be associated with several distinguished figures in American politics, including Thomas Jefferson and James Madison, in which states would band together and would kind of rally to bring about the repeal of federal laws. So we do have a history in American politics of state resistance. But I would say in the last 15 years, the state resistance has ramped up. And it takes various forms. One form it clearly takes is filing lawsuits, where state officials will go to court and say, we challenge this particular federal policy. It can also take the form of state officials declining to help enforce federal laws. And the Supreme Court doctrine is very supportive of states in this regard. They say you don't have to help federal officials enforce federal law. You can't thwart them, but you don't have to affirmatively help them. And that has been very much increasing. And then there's also another form that state resistance can take. Sometimes states will actually pass policies that are inconsistent with federal policies, and their intent is to get this before the courts to actually get it tested. And sometimes those efforts result in actually the court siding with the states and saying, actually, the state law is the one that survives this conflict between state and federal laws.
We're seeing this recently with the reactions at the state level to the Trump administration's efforts with ICE, and a lot of state officials resist that. And one case that I teach my students, Prince, dealing with the Brady handgun. So, are there meaningful differences between how Republican led states resisted the Biden administration and Democratic led states have resisted the Trump administration? Or is it all the same kind of methods, like lawsuits, as you say?
Yeah. The most notable difference, because the most prominent of the pushback strategies has been the filing of lawsuits. State attorneys general filing individual lawsuits or banding together to file lawsuits. And the main difference is that where these lawsuits are filed. If we look around at the federal courts, there are a number of federal courts that the majority of those judges were appointed by, say, a Republican president, or most of the judges on this particular court, a district court or circuit court, were appointed by Democratic presidents. And so where these cases are originally filed differs dramatically depending on whether we're talking about a Republican president or Democratic president. Under the Biden administration, as well as under the Obama administration, turns out that Texas and Oklahoma are the main places where attorneys general kind of filed their lawsuit, and they hope to get a favorable ruling. When we come to the Trump administration, multiple Trump administrations, those cases are much more likely to be filed in California, in Maryland, in New Jersey, and New York. But the main point is that the difference there is just where you're filing that initial case. I should say one other thing here, and this is why it's important where you file this case, because eventually, say, don't the cases get up to the U.S. Supreme Court? Doesn't it all wash out there? But another notable development in American politics in the last 15 years is the development of the nationwide injunction, where a single federal district judge, that's the trial level judge, will hear a case where a state attorney general will be challenging a presidential order. And a single federal district judge will say, I am therefore preventing this law from taking effect. And I'm doing so not just in my district, but I'm issuing this of nationwide effect. So it makes a big deal if you can go and get a favorable ruling from, say, a Texas court to do that. As I say, that's temporary. It works its way up through the system. But still, that's an enormous consequence if you can actually block a presidential order through the actions of a single federal judge.
I have to rethink how I teach this because I've always thought about district judges and the appeals courts of having jurisdictions. For instance, I've heard about a federal judge in Lubbock who is maybe appointed by Trump. I've heard that's a favorite jurisdiction. And then I'm like, oh, well, that makes sense because the Fifth Circuit, which Texas is a part of, it historically has a reputation for being conservative. But even then, I was still thinking, well, the Lubbock judge's jurisdiction would just be North Texas. So that's not always the case.
No, increasingly, these idea of nationwide injunctions issued by single federal judges were very uncommon up until about 15 years ago, and now they're quite common. Now, I will say the U.S. Supreme Court, about a year ago, they started putting some restrictions on these abilities of individual federal judges to issue these nationwide injunctions that would apply not just in their district, but more broadly. So we'll see whether this development is blunted to some effect.
Well, it's just proof that the law changes. It's not just how they rule, but how the law is actually operating. It's not static. And so I'll read a statement to you, and then I'd like to get your reaction. Federalism has become a vehicle for partisan conflict rather than a mechanism for good governance.
In my own view, I would take out the rather than, I would replace it with and. That is, I would say that federalism is a tool of partisan conflict and it is a mechanism of good governance. And the way I would put this is here is, let's talk about the way we view our separation of powers system. That is our relation between, say, the president, the Congress, and the judiciary. We fully expect that when a president is a member of one party and members of Congress from another party, that they're going to not see eye to eye in part because they have different partisan views, but they're also going to each kind of act in the ways that presidents will act and that Congress is going to push back in its congressional role. And we're going to see partisanship, but we're also going to believe that a separation of powers is going to lead to good governance by dividing power and allowing not power to be too centralized. I would say the same thing is true for federalism. That is, we shouldn't be surprised when different state officials might be Republicans, might react to a Democratic presidential administration or vice versa. And certainly there's going to be a partisan dimension to that. But we can also view that as contributing in the end to good governance by placing an appropriate check on the power of the president or the power of Congress, just as we would view separation of powers as providing appropriate checks and balances. We can also see the division of power between states and federal government as ultimately contributing to good governance and preventing too much of a consolidation of power.
I feel like that's such an important lesson. Folks often get frustrated at sometimes the slow pace of legislative action, but we forget that those checks and balances are there for a reason and that federalism itself is a check and balance on what's happening in DC. We're maybe an impatient people, and so that can be a challenge sometimes. So I always like to conclude by encouraging the listeners to continue learning after the episode is over. If someone wanted to better understand state politics, federalism, or direct democracy, do you have readings that you recommend for someone to start their learning journey on this topic?
So I'm going to select one of my own works, and that is a book that I wrote called The American State Constitutional Tradition. And in that book, I particularly focus on state constitutions. And what I particularly focus on is how frequently state constitutions change over time. The U.S. Constitution has been amended 27 times total, and 10 of those times were the Bill of Rights. So that means the U.S. Constitution is not changed very often at all through the formal amendment process. And yet, state constitutions change on a regular basis, and they oftentimes change where actually people will rewrite the whole Constitution. They will call a constitutional convention. We've only had one constitutional convention at the federal level, 1787. But we have, by some counts, 250 state constitutional conventions that have been held to either draft initially or to revise and amend state constitutions. And I, in that book, call attention to this proliferation of state constitutional revision, which results in a lot of documents that look very different from the federal Constitution because they, in some ways, represent the sum total of people's experience over time, over some 250 years. And so that's going to lead to a different structure of state constitutions, different rights in them, and different policies.
That's a great recommendation, and I'll include a link in the show notes. Once again, John Dinan, Wake Forest University, thank you so much for your time. Really appreciate the knowledge you've imparted with us today.
Well, thanks so much. I really enjoyed the conversation.